My name is Jessica Saxton. I'm a civil rights advocate and litigator from Washington, D.C. I'm here to provide public
Can I
notice.
get your address and city that you reside in?
From its,
Point of order, Mr. President. If she's getting ready to do something legal with this, she needs to be talking with Mr. Riley instead of a public meeting. And I may be wrong, but it sounded like you were getting ready to talk legal.
no, this is simply, simply a public notice to put on the public record here today.
Mr. Riley, what do you say?
I haven't heard anything yet that would preclude her from speaking.
Sounds good, but we,
No, that's okay.
We have a rule about legal stuff.
I understand. No,
but I will need your, not just your name, but your address and your city.
it's
of residence.
152 Wayne Place, Southeast, Washington, D.C.
Thank you.
So, like I said, my name is Jessica Saxton. I'm a civil rights advocate and litigator from Washington, D.C. I'm simply here to provide a public notice to the City Council of Huntsville, Alabama. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court.
Okay, hold on just a second. I'll suspend the time. This does sound like a legal matter.
This isn't a legal notice.
You're talking about a public notice. That's a legal matter.
It's
I mean,
just, it's a public notice in the opinion of the public, so.
Okay. I believe we're still on solid.
Okay, go ahead. And you didn't lose a second of time. Go
Okay.
ahead.
Thank you so much. The Constitution of the United States of America is the overarching requirement that every state must follow. I trust that everyone here would agree with that. States are not able to enact their own alternative legislation in substitution for the guarantees of the Constitution. That would mean that your state laws are, in fact, more superior than the Constitution, and that is unconstitutional. Clause 1 of Amendment 5 states that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. However, the state of Alabama has enacted its own alternative legislation that substitutes the guarantees of the Constitution. So your alternative legislation permits prosecuting attorneys, police officers to charge by way of information as opposed to indictment. That is unconstitutional. An emolument violation is when you pay a public official to commit a crime. There are two areas of the Constitution that enforces this. The first is Article 1, Section 10, where it states that no state shall create a law that shall impair the obligation of contracts. So police officers, prosecutors, judges are all under a contract to perform based on the oath or affirmation that they took to support and defend the Constitution. The contract perimeters within the Constitution of the United States. Unfortunately, when a state enacts a law that directs their agents to disobey the law, which is the Constitution, that would be a violation of Article 1, Section 10. The 14th Amendment is the other place that you find this reinforcement, and that states that no state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens. Privileges and immunities of United States citizens are already a minimum those that are guaranteed in the Bill of Rights, the first 10 amendments. The state of Alabama has enacted a law in its inferior constitution that is permitting public officials and law enforcement, whom you all pay, to violate the Constitution of the United States. As a result, there is an inordinate amount of people currently imprisoned here in the state of Alabama illegally and unconstitutionally. We are preparing to litigate this at the United States Supreme Court on behalf of more than 700,000 people currently imprisoned here in America unconstitutionally. So I'm here today simply to provide you notice that you cannot continue to pay public officials to break the law. Criminal sanctions can come from that. That's not any direction that anyone wants to go. Nonetheless, we have to make officials aware that paying people to disobey the law is an emolument violation. It is illegal. It is unconstitutional. It is a crime. So I'm asking you, honorable individuals, to please take a look at Clause 1, Amendment 5, confirm what I'm saying to be true, and direct your public officials to act in a lawful, constitutional manner consistent with the obligations that are codified in the Constitution of the United States of America. I have a notice I'd like to put on the record, please.
Thank you, ma'am. Our next speaker is Tawana Downing. Oh, I thought that was Ms. Saxton. Oh, okay. Go ahead, sir.
So my name's Tawana Downing. I'm the civil rights litigator that Ms. Saxton was just talking about. So I'm here, I just want to provide just a little bit of clarification. I know that some of the things that you guys just heard.
Sorry
Yes?
to interrupt. address and city.
Okay. The address is 152 Wayne Place, Southeast Washington, D.C., sir.
Thank you, sir.
Absolutely. Thank you. So I just want to provide a little bit of clarification because I know that what you just heard might be a little bit foreign. Mr. Riley earlier, honorable individual, he made a statement where he said that the city here can't amend state statute. The issue is that the state can't amend federal statute, certainly not the Constitution of the United States. So there's a crime, Title 18, subsection 242. It's called deprivation of rights under color of law. And what that particular statute says, it says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. So when your public officials, the law enforcement, your prosecutors, and judges, when they go out and they choose to rely upon that inferior state statute that permits them to charge by way of information, not by indictment, that would obviously be a violation of Title 18, subsection 242. So I have approximately 32,000 criminal affidavits on behalf of affected victims that this particular issue has happened. Many of them are located right here in the city of Huntsville, but within the state of Alabama, we have 32,000. So I know that you guys are going to go and you're going to ask your city attorney as soon as we're done here whether or not this is true. That city attorney is going to tell you that, well, not really, because of a Supreme Court decision from 1884 called Hurtado versus California. And before you guys choose to rely upon that advice, I want to remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. That must be done by an authentic act in accordance with the special amending procedure of Article 5. Judges cannot legislate. So when the Supreme Court of the United States directed the state of Alabama to permit you guys to abridge the obligations codified and enumerated within the Constitution of the United States, requiring an indictment by a grand jury before arresting someone and holding them over in accordance with Clause 1, Amendment 5, the state of Alabama had no authority to rely upon that judge-made ruling to do that because judges do not have authority to legislate. Clause 1, Article 1 says all legislative powers vested in Congress of the United States consisting of the Senate and House of Representatives. So, we're here today to let you guys know the situation and ask you guys to please step up, discharge the duties of your office, fulfill the obligations and promises that you made to people of the state of Alabama, and let's choose to preserve, protect, and defend the Constitution of the United States against all enemies, foreign and domestic. Thank you guys so much. God bless.
Thank you, sir.